All rise. Supreme Court of Guam Sound Section. The Honorable Chief Justice Robert J. Torres presiding.
Good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA23-007, People of Guam Plaintiff Appellee versus Bruno Frankie Simmons, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Daniel Morris. Appearing for Defendant Appellant is Attorney William Pohl. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Attorney Pohl reserves 5 minutes for rebuttal.
You may proceed, Mr. Pohl.
Chief Justice Torres, Justice Carbolito, Justice Merriman, if it may please the court, this is a consolidated case involving Bruno Frankie Simmons. He has 2 cases, CM 432-22 and CF 095-23. In both cases, the Superior Court decided that the case should be dismissed, but then reserved on whether the dismissal should be with or without prejudice. In both cases, the Superior Court decided that it should be a dismissal without prejudice. This appeal is on whether or not that's an abuse of discretion for the 2 cases. It should be clear that CM 432-22 and CF 095-23 involved the same police report and involved initially the same charges. In CM 432-22, the defendant was charged with unauthorized use of a motor vehicle, which is really not the applicable issue here, as well as criminal trespass.
Before we get to the merits of the argument on a speedy trial, I want to address the jurisdictional issue. Because one of the bases, I mean, you had pointed out that while we've held a writ of mandate as the forum for challenging a pretrial denial of a dismissal, we haven't addressed how one should bring an appeal of a trial court's determination of whether the dismissal should be with or without prejudice. And you relied on one of the provisions you relied on was 8 GCA 130.15C, but the plain language of that references it's from an order made after judgment affecting the substantial rights of the defendant, and in this case we have no judgment, right? Well, you're arguing that the 150 days pass applying the civil rules, the GRAP rules, to say 150 days passed, and therefore the order becomes de facto a judgment?
That's correct, Chief Justice. So when I originally was approached with filing this appeal, I was concerned on whether or not there was jurisdiction. But of course, once a client asks you to appeal, even if you don't think there's an appellate issue, you're required to appeal anyways. But as part of that, I looked at it's paragraph 25 of the Gutierrez decision, 2005 Guam 19. And I understand that it was probably dicta in the sense that it was not part of the ruling per se in Gutierrez. But in Gutierrez, this court says that the reason that the Superior Court retained jurisdiction was because the defendants did not appeal the dismissal without prejudice order, at least indicating that that order would have been appealable. And I believe that the Superior Court, both trials, did it correctly in the sense that when we look at if the Superior Court denies a dismissal, then you would have had to do a writ of mandate. But as this court indicated, that writ of mandate would not include whether or not it was with or without prejudice. So I believe that the 2-step process that the Superior Court judges adopted are consistent with the Supreme Court.
Well, what about taking a petition for interlocutory review of the trial court's decision to not dismiss with prejudice?
It could have been done
Since, I mean, if we reject that, because you're relying on the GRAP Rule 4A, which specifically applies to appeals in civil cases, it's to my knowledge, never been applied to a criminal appeal to say that an order of the court 150 days after entry of the judgment, when it finally disposes of a matter, can be appealed.
And that's a good point. I would say that when we look at the Gutierrez decision, again, the issue of whether or not a dismissal should be with or without prejudice, it was not until CF 95-23 was filed. And so that until there was two cases, and we have this unique set of circumstances where we have a new case based upon the same charges, but then the new charges are dismissed for lack of probable cause. And so that if CF 95-23 had not been filed, it would not have been clear that that there could have been an appeal of the first decision.
I still want to go back
Okay.
to the Chief Justice's question in terms of the 150-day. I don't know if you can hear me, but no, all right. So I mean, in terms of the rule, the entry of judgment after 150 days, we did in Marriott v. Marriott. I mean, what would be the rationale for us extending that in the criminal cases? I mean, there are separate concerns, and it cuts both ways, and it can come back to be detrimental to the defendant in allowing the prosecution to appeal 10 days after entry of a judgment, 150 days later. So, I mean, what would be the reasoning for us to treat that similarly?
Well, one, and it's a very good question. One, this court has already determined, again in Gutierrez, that there did not need to be a final judgment for the government to appeal. And so,
But that's statutory. That's a statute specifically in a separate statutory provision.
well, 130.15 indicates that there should be a final judgment before an appeal. And this court said that there was no need to be a final judgment for the government. And so, again, in terms of consistency and the fact that there is no current rule on how to interpret a final order in a criminal case, that consistency, and I believe that is part of the local rules, that that the local rules of the Superior Court apply to all cases except for when either they explicitly do not apply or when there's reason not to apply them. And so in terms of the defendant's rights, and there's no reason to assume that the 150-day rule would not apply. And I guess the argument would be, in terms of detriment, that's where a habeas corpus petition potentially would be appropriate. And I did, and there's no question, I struggled legally with whether or not that this was the appropriate method. But when looking at that, a writ of should be done for whether it's dismissal or not dismissal, and that writ does not include with or without prejudice, well, with what this court has done in Gutierrez, it seemed to be consistent with how the Supreme Court has handled it, and also consistent with how the Superior Court determined that it would retain jurisdiction to hear whether it should be with or without prejudice. If they need to retain jurisdiction to hear it, presumably that is a final order that is equivalent to a judgment. And there is no, and the reason I quoted Marriott is that I couldn't find anything that requires a judgment, a separate document called judgment.
But what about going via the discretionary review of interlocutory appeals? I mean, it doesn't require a final judgment. You just have to satisfy the standard. You didn't raise that here. And so it may not be an issue, but it's something that should have been considered.
And I guess the question, it's always the question of anybody who we don't want to miss the time frame. And if we filed a discretionary appeal and it turns out that it's not discretionary, then you might have lost out on the appeal itself. And here, because we have, and I think this is a unique set of circumstances, we have both the issue of whether or not the government followed the speedy trial clock, but also the due process rights of the defendant. The defendant for both cases was always asserted. On the eve in both cases, one at a pretrial conference and one literally hours before we were supposed to go to trial, or minutes actually, the government moves to dismiss. So this is a unique set of circumstances that seem to be appropriate for a direct appeal on the issue of prejudice, because not only does it affect the substantial rights of the defendant as the government interfered with his parole case based upon these cases, and which is why I quoted from Padilla, which was an immigration case where prosecutors must be aware of the collateral consequences, and that as provided by the Ninth Circuit on multiplicity, United States versus Zappa, that collateral consequences can affect the substantial rights of the defendant, even if it can't be quantified. But in this particular case, we can quantify it. He's being held on, I didn't give the case numbers because I wasn't sure if they were relevant, but he's being held on CF 40-18 and CF 4087-17 on a parole hold, partly based because the prosecutor said that he had been charged with burglary, which rises to the question of why did they increase the charges when there seems to be very clear case law that would discourage trying to make a disorderly conduct into a burglary.
But we have a presumption of that the government files the charges, and we presume that they do that in good faith. And the trial judge, when the government articulated its reasons in reference to refiling the charges, didn't seem to find that there was any bad faith on the part of the government.
And I would argue that that's part of the abuse of discretion in this case. When you charge, recharge, that, it's prosecutorial harassment. That's People versus Gutierrez, 2005, Guam 19, paragraph.
But this
40.
was just once that they recharged. I mean, you don't see some of the case law where there were all these successive filing and dismissals, and it started to raise a red flag. I mean, there was a reason that was provided in this one dismissal and recharged.
Yes. I would say a couple of things to that, Justice Carbolito. One, the government purposely held these two cases, even though it was only for a couple of days, the government purposely held these two cases out at the same time, which is an unusual fact in itself. It blurs whether this should be considered a separate indictment or a superseding indictment, where the defendant clearly objected in the first case. The government argued, hey, we reviewed this case, even though you've asserted, even though we're going to go to trial, we want to get a better position by having a higher charge. And as the court in CF 95-23 found, how do you have disorderly conduct inside of somebody's dwelling? That is the basis of the burglary charge. That's the basis of continuing it. And so that there was never any good faith basis to increase the charge based upon the allegations. And so that's.
But you got the result that you sought in reference to filing the motion to dismiss, or your client did. Those two cases were dismissed.
That is correct, but
and they haven't been recharged.
At this time, they've not been recharged, but they were the basis, or one of the bases of his parole hold. It was one of the bases that he had been held between December 6, 2020.
Let's see, is your contention that the parole board cannot consider other factors that may affect its exercise of their discretion?
They can, and that's a good point. But in this case, he was held since he was charged. So he was held by parole board December 6, 2022, based on the charges in CM 432-22. Then the chief prosecutor at that time goes, he's been charged with burglary. The CF 9523, even though she knew or should have known at the time she made that argument that that charge was already dismissed.
But
So we have actual.
isn't the only evidence that you provided on appeal that is that article that shows that he was being held because of the criminal felony case? And doesn't that also indicate that that was just one of several factors that was used in determining his parole status? And in fact, there was negative testimony from the sister. There were other cases that he had. So she also said that it was, I think that in the interview, someone said that he was not a good candidate for parole. So there were these other factors besides just the criminal felony.
That would be true as why they decided to revoke parole, but not why they decided to hold him from December 6th. They held him until the determination that they were going to revoke. Because of course, if he had not been out.
Then wouldn't the remedy be that there was some abuse of discretion on the part of the parole board? And that's
I have filed a motion requesting an attorney to be appointed in those cases so that he can file a habeas corpus petition. That motion has not been heard yet. And so I don't disagree that that is a avenue that he can follow. But in terms of the government going around the speedy trial clock, not one, and it's important, it's not once, but twice. And the reason given in CF 95-23 not to try him is they didn't want to bring a police officer back from vacation. They held him, they recharged him, they lost on those charges. And then again, we came in the morning for trial selection and the government's, we don't have our primary witness. And they decide to remove it. So we do not have, I would say, the normal case of the government's just tried a couple of different times to charge this guy. Twice they've evaded the speedy trial clock.
but in that case, I mean, in reference to the government's motion to dismiss because of the lack of the witness, I mean, the case was dismissed. And your client is not facing charges that are refiled. And if those charges are refiled, then wouldn't that be the appropriate time to raise whether or not there's been a violation of the speedy trial?
Well, Your Honor, Justice Carbolito, I would provide that because CF 95-23 was the second case.
Yeah.
That there was it's now right to look at whether or not CM 432 should have been dismissed with prejudice. And part of looking at that is looking at the government.
Hasn't the statute of limitations expired on those misdemeanors?
I don't believe so because during the whole entire,
didn't the crime occur in December of 2022?
He was not, so the final, I believe that the final dismissal was not until the July of 2023. So arguably they would have until July of 2024. And if you believe the burglary allows all charges, presumably the burglary would be a 3-year statute of limitation. So while we may,
but I'm talking about the misdemeanors. You're talking about the 2 misdemeanors of criminal trespass and unauthorized use of a vehicle, right?
Right, but they were charged again in CF 95-23 and not dismissed until July of 2020.
Yeah, but as you point out, they came from the same police report, came from the same facts. So presumably they would have had since the time that crime occurred to charge those, which would have been December through December of 23, right?
I would believe that following the reasoning of the court, that when this case was when 432 was dismissed, it would be 1 year from that date, because any time that 432-22 was pending before the court, the statute of limitations is held during that period of time.
So we dismissed that case in February 28th.
Well, and this goes back to the argument on why this appeal is appropriate, that if this court determines that the appeal is from the date of dismissal, not whether or not it was dismissal with prejudice. And that is an order after a final decision of the court. And again, I believe that the Superior Court did the appropriate two-step process pursuant to Guam Supreme Court case law. First, you decide whether it should be dismissed, which will become a judgment of the case. It should be dismissal, and with or without prejudice, which again clearly affects the substantial rights, including the fact that if this case gets dismissed with prejudice, now arguably the defendant would be able to go back to the parole board and argue reconsideration of whether he's being held or not, so that there are clearly collateral issues that are still relevant and not moot, as well as when we look at the factors in People versus Corpus 2019 Guam 1, this paragraph 21, this seems to be the exact kind of case that if you believe the speedy trial was violated, that there should be a dismissal. The seriousness of the offenses are not so severe as it would be unreasonable to dismiss the charges. They're just misdemeanors. And that when we look at the fact that the court, excuse me, not the court, but the government led to the dismissal was they were not prepared a second time. And I don't think that can be underestimated. It is one thing to say the government wasn't prepared once, and so we're going to dismiss, and then we have the second case. But twice the government is unprepared to go to trial, and the defendant never wavered on his speedy trial. He never wavered on his desire to go to trial on these charges. And those factors and the impact of reprosecution, I would say that it is just as important that no guilty person goes unpunished. It's equally important that the government be required to follow the law and procedures. And they clearly did not care, based upon their actions, on the speedy trial rights of the defendant. They didn't even attempt to bring back the officer. They just said they're not going to do it. And again, they didn't give notice. They didn't give any kind. And that is also one of the things that the court can look at is, was there reasonable notice given? And reasonable notice is not the day of trial. And that when something gets dismissed, there has to be shown an ends of justice.
So let's go to the prejudice that if we were going to examine the speedy trial violation, and even if we're persuaded that there was a violation of his speedy trial rights under the statutory 8060, don't we have a presumptively prejudicial test or a timeline that's been interpreted to be over a year or longer? So how is the time in this case presumptively prejudicial?
Yes, my understanding of U.S. Supreme Court law, as it approaches a year, it's presumptively. And here we have 8 months. It's not all that far under a year. And which is why we do quote from a couple of cases from Ohio where they found even a 5-month delay from indictment or from arrest to grand jury could be sufficient to violate the speedy trial.
But wasn't the time between the filing of the subsequent indictment and the dismissal about 160 days or thereabouts, so more around 5 months?
Well, I would say that if he's been in prison, whether on this charge or not, since December 6, 2022, and that is for CM 43222, and I believe that he was released on July 12, 2023. So if we just use those two dates as the dates, we have well over 8 months at that point of being under, am I going to go to trial? What is going to happen to me? Am I going to be charged? So that we do approach that 1 year at 8 months. And of course, the time itself is not necessarily dispositive, but again, when we look at the severity of the charges, the idea that the government should get a third try, especially when we have, and I understand it's only a 2-day overlap, They didn't dismiss this case until they were sure that they got the new indictment. And again, that seems to not be what they should have dismissed the first charge, the first case, before trying to get a second case. That seems to be what Gutierrez would indicate. That would be seen to be what our case law would require to distinguish between a new indictment and a superseding, because that's literally the definition, is whether or not there's a case pending. So that when we look at all the, and I would argue this is a unique set of factors, that this is where Flores comes in and says that if there's sufficient evidence that the government went around the speedy trial and did not act in good faith in bringing these cases in a prompt manner, then in that narrow set of circumstances, a dismissal with prejudice is possible. And so that we're not looking at a set of cases as likely to have major impact on the ability of prosecution to prosecute cases or to bring forward cases. What they can't do is continually say, we're going to go to trial. And, anybody who's gone to trial, I don't know, I can't say that I truly understand what it's like to be in the defendant's shoe, but as an attorney, every time you go to trial or you go before a court, you're nervous and you prepare and you are discomforted. And so he did this not once, but twice. And the fact that the government seemed to, I would argue, recklessly dismiss the second case because they were not ready. And again, when Gutierrez says, if you dismiss a case because you're not ready, it should be with prejudice. Take a look at paragraph 66. And Gutierrez is a very big decision. And I understand that it is normally thought of as the case where the government, as in Gutierrez, just does it over and over and over again. But here, I've not seen a set of cases where twice somebody's set for speedy trial and for no fault of the defendant, that the government dismisses the case because they're not ready to go forward. And that seems to be exactly what Gutierrez stands for. When the government is not ready, that's not a good reason, including...
You have 4 minutes left, Mr. Paul, so I didn't know if you wanted to reserve.
I will reserve the last 4 minutes. Thank you.
For the people. Cody.
Mr. Chief Justice, may it please the court. On behalf of the people, I'd like to focus on two issues that I think decide this matter and can aid the court in determination. The first of it is the jurisdiction question. And the second would be, I'd like to return to a closer discussion of the standards of review here and the presumptions at play. On jurisdiction, I think, with all due respect, that there is no authority. Appellant certainly has cited no authority that permits this appeal to be heard. And jurisdiction is sufficiently important, of course, to the court that it can be raised sua sponte, but it has been addressed here by the parties. The core problem is one of finality. Dismissal without prejudice of criminal charges is not a final order. All of the statutory basis that the appellant has cited, whether that's 7 GCA 3107B, which refers to final orders, 3108A, which refers to final judgment. This concept of finality is a key one in the court. Now, that doesn't mean that the defendant appellant, Mr. Simmons, was without remedy. He had at least two. As the court's already discussed this morning, there's a potential for interlocutory review. As is discussed in defendant appellant's briefs, these issues have also traditionally been brought by writ of mandamus. The interesting thing is that statute specifically provides that those writs issue where an adequate remedy is not available in the ordinary course of law. And I think we can all agree this is not an ordinary appeal. And it is so such that extraordinary relief would have been more appropriate. Lacking jurisdiction, the appeal shouldn't be heard. A note on the argument regarding the jurisdictional divestiture in Gutierrez. Read in context, I think that the quoted portion refers more properly to the fact that the people's arguments in that case, the court had some criticisms for. Among those was an attempt to assert jurisdictional divestiture as a basis that the trial court's reconsideration of the order was inappropriate. And the court was just properly pointing out that jurisdictional divestiture occurs upon notice of appeal, not before it. So I think that for our purposes here today, that Gutierrez language doesn't substantively inform the appeal.
Mr. Morris, should we consider this? In the alternative, it's a writ of mandamus rather than dismiss this appeal and let Mr. Paul bring a writ for judicial economy's sake.
No, Your Honor. I understood. I anticipated the question and wondered about it myself because we certainly never want to force the parties to go through hoops unnecessarily. But writ proceedings are fundamentally different. The Superior Court is sometimes merely a nominal respondent, and sometimes it's much more than a nominal respondent. And we do not have the ability to get that involvement or to permit that involvement in this appeal. I'd also point out that my understanding, my limited understanding at least, is that appellate courts always have to keep their eyes on at least two questions. The larger public policy question of what will result from a ruling today, and the more compelling sometimes question of what's justice for the parties before me. Well, here there are legitimate public policy concerns about loosening the bases of the finality rule or permitting or incentivizing attempts to get around those proper procedures as laid forth. And it's hard to say that there is any great prejudice to this defendant appellant who, as the courts point out, hasn't been recharged. And in all likelihood, the passing of the statute of limitations precludes further charging in this action.
Does that make the matter on whether the criminal misdemeanor charges could violate speedy trial moot because the prosecution for an offense which is not a felony has to be commenced within 1 year after it's committed, and it was committed in December 2022?
I would say no for I think two reasons. First is I have not admittedly done a deep dive on the potential theories on tolling statute of limitations. It appears to me, as I stand here today, that any misdemeanors arising from the December 5th arrest have long since are now time barred. But I wouldn't want necessarily to represent that if there were compelling reasons why we needed to recharge that case, I wouldn't be scouring the law for a basis that they were still within the applicable time procedures. The second, in all fairness to the defendant appellant, while I think as a practical matter, any charge arising from that December 5th arrest on a misdemeanor level is time barred. And the only felony that's been identified requires some underlying crime that it was intended. And at the time, the prosecutors could only identify another misdemeanor. So as a practical matter, it appears that it is time barred and moot. There remains the possibility that some further evidence would arise from the December 5th, related to that December 5th arrest that would lead to further charges, potentially including felony charges.
And Mr. Morris, I know you weren't the prosecutor in this instance, but when you look at a plain reading of the statutes that were used in the criminal felony indictment, it should have alerted to the people that there were clearly legal deficiencies in the superseding indictment. And, it seems, I mean, I don't want to say bad faith, but clearly you had the criminal misdemeanor charges, then you have these new charges brought before the grand jury that clearly the judge found were legally deficient. And I think a plain reading of the statute would have shown that. And then all you're left is the same criminal misdemeanor charges you had at the beginning. And you've now got the trial dismissed and and continued on this premise of new charges, but really were, I don't want to say trumped up, but, you know, were clearly inappropriate.
Mr. Chief Justice, I believe I have 3 responses, although I understand the concern. The first is getting it wrong doesn't prove bad faith. There's a reason why we have the presumption of good faith because, and one of those, and part of that rationale is that sometimes prosecutors are going to get it wrong, even through their best efforts. And they're placed in a position where sometimes they do. Zealous advocacy and their duties as a prosecutor requires them to go out past our comfort zones. The second response would be, I understand the argument that it's impossible to, from the same conduct, have both a burglary and disorderly conduct, because one requires an entry into a private place and disorderly conduct requires some sort of public display. I can think of an example where both would be entirely appropriate, which is I want to harass the parade as it passes by. I know of an empty apartment where I can lean out the window and shout obscenities. That fits the essential elements for both of those crimes. That, of course, wasn't the facts here. I was not a part of that charging decision, so can't speak.
So let me ask this question, and for burglary, does it require that the other crime charge that it has to be proven in order for burglary to be proven?
My understanding of the essential elements of burglary is that it would be the people's burden to prove beyond a reasonable doubt an intent to commit a crime. So to that extent, you wouldn't necessarily need to prove the subsequent commission of a crime, but you would need to prove that the defendant had an intent to so commit a crime.
So in terms of what happened here, if the prosecutor felt that there was an intent to commit the crime of criminal mischief, was a prosecutor required to prove criminal mischief in order for burglary to be proven?
I do not understand the applicable law to require affirmatively proving the commission of that crime. Well, again, the prosecutor would need to prove to make out the elements for the burglary, the intent to commit it. And I think generally that actually helps us get to the standard of review concerns, which I don't believe have been adequately I don't know the briefs have been as helpful to the court as ideal. The abuse of discretion standard, as the court knows, requires identification that the decision was made on a clearly erroneous conclusion of law, or that there is no evidence on the record that would support the factual findings of the trial courts. And here, two trial courts found separately that the people acted in good faith. I have not heard from the defendant appellant an argument that those trial courts applied an erroneous conclusion of law. And I have not heard them argue that there was no evidence of record to support the factual findings of the court. What I've heard is they think the trial courts got it wrong. They would have decided it differently, and they are urging this court to decide it differently. But an abuse of discretion standard does not permit that review. And even beneath this, and this was an issue that I believe the trial courts addressed, the people are entitled to a presumption of good faith. So again, it is initially the defendant appellant's burden to identify some facts, some evidence that at least give the appearance that the people are not acting in good faith. Now, I understand the criticism that both times these dismissals happened on the eve of trial. It's important to remember, of course, that that is the time when a prosecutor is most focused on his or her case, is as they're preparing for trial. This court has held, the Ninth Circuit has noted in the Garza Juarez case that in the course of preparing a case for trial, prosecutor may uncover additional information that suggests a basis for further prosecution, may simply come to realize information he already possessed has greater significance. This is a natural process of the law, and that was in fact the basis for that the people provided for seeking dismissal is that upon further review by the former acting chief prosecutor, they'd identify additional charges that should be brought, and because one of them was a felony, required going to the grand jury, demonstrating the probable cause such that an indictment could issue. As to the second dismissal, again, on the eve of trial, there is no record evidence that the people did nothing to try to get that police officer to come to the island. There is, in fact, based on the argument of the people's motion regarding the fact that the police officer would have had prepaid for an expensive, particularly expensive trip, that the people had actually made some strenuous effort to try to convince that police officer to return. And again, this court has argued that unexpected unavailability of counsel or witness is an example of good faith dismissal. That was in Flores, paragraph 32. Significantly, the people didn't on that day first seek dismissal. They weren't seeking to avoid trial. They asked the court to permit this police officer to testify by Zoom. And I think you'll see in the record at 132 through 39, the trial prosecutor, Mr. Grant-Olin, actually argued with some zeal for permitting that witness to deliver his testimony via Zoom. That was the people's preferred alternative. If that wasn't available, the court also asked, okay, let's impanel the jury, but let's have a 17 days, a 17-day postponement before the taking of evidence so that the police officer could return. That was the people's first alternative or second option. It was only when both of those were removed that the people sought dismissal. Dismissal is not the preferred outcome here. That's a further indication the people's intention was to try this case.
Will you address defense's argument about the lingering of the initial case on the re-indictment of the second one, the 2-day gap? Go ahead.
Again, I don't know that there's evidence that I don't know that it's reasonable to infer bad faith from that 2-day gap. I think it's entirely consistent that in a situation where a superseding indictment is not available, because again, the initial action was brought on a magistrate's complaint without a grand jury, so we had to go to a grand jury. It is entirely reasonable for a prosecutor before dismissing an action to make sure that he's able to bring the second action. So it was entirely appropriate for the prosecutor to go and seek to secure the indictment before dismissing the magistrate's complaint. 2 days is a very small amount of delay. The record doesn't reflect the basis for that. I don't know that 2 days, I don't know that any great prejudice was wrought to the defendant appellant from those 2 days. And I haven't heard explained to me, I haven't heard from defendant appellant the basis for any prejudice arising from that.
So you completely discount his argument that regarding the parole hold?
The parole hold is a challenging issue. It's important to note that the prejudice of the parole hold was almost entirely of the defendant appellant's own making. He was subject to action by the parole board because of his previous criminal conduct resulting in a criminal conviction. The parole hold was triggered by probable cause that crimes had been committed as attested to by a grand jury. It's undeniable. Detention is prejudice. No one, I don't know that anyone wants to be detained, but this situation was largely of the defendant appellant's own making. And it's unfair to suggest that, and it's inappropriate to suggest that the people doing their job, asserting charges for which there is probable cause, was unfair prejudice to the defendant appellant. I think that's how I understand. And then as to the later hearing, I do think that the only article about the later parole board hearing two things. As Chief Justice noticed, it seems like there's a lot of reasons why that parole hearing did not go well with this defendant appellant. Second, that article provides only a very small snapshot. We do not know all of the considerations, at least from that article, that the parole board had before them. It does appear that the acting chief prosecutor's comments, then acting chief prosecutor's comments, were appropriate. She said that, among other things, there was this issue with contraband in the prison. He'd previously been convicted of robbery, and he had recently been charged with robbery. All of those things are factually true. So I think the parole it makes us feel that there is some prejudice that requires remedy. But I would suggest that it's largely the result of, again, the defendant's own conduct, previous conduct.
So would your office be under an obligation to enter a judgment saying that this case was dismissed with prejudice at this point?
I do not. No, I don't think so. I think for two reasons. First is, well, I think they're the same reason. While I believe from all evidence that as a practical matter, no new charges will be brought, a witness could walk into the office tomorrow, providing new evidence that would require related to these same circumstances and the same arrest that would impel prosecution, reasonably impel prosecution, and it would actually be a failure of our duty to enter into a judgment or stipulation of acquittal precipitously. Although again, I think this is again an unusual case in that it seems as such that there are, and I can represent to the court. I spoke with prosecution yesterday, and there are no present intentions to recharge this matter. But as I say that, I also have to say that yes, should a new witness appear or should circumstances change, and there's a legal basis for moving forward, it would. And so it is a case where almost certainly the matter is entirely resolved, but there remains, yes, that potential. I'm sorry if that adequately answer the question.
What about
It just seems this is an unusual case where there may be actual prejudice established to the defendant beyond the scope of what happened in the courtroom, but that's why I'm asking what the position is. Thank you.
I would also note that I'm actually going to stop that point because I don't know that going further with that would be beneficial to the court. We do have.
Let me ask this question in a separate matter. What about the defendant's argument that the court should consider extending the 150-day rule for entry of judgment to criminal cases? What's the government's take on that?
It's counterproductive. Again, the reason why that suggestion is being made is because there is no authority for this appeal, which we all agree is extraordinary. There is nonetheless remains, as I discussed earlier, a mechanism for the defendant appellant here to properly bring this matter before the court. Anytime the finality is one of those regrettably already complex areas of jurisprudence, regardless of the jurisdiction, any further modification of it likely only guarantees further unintended consequences. There is not a pressing need to make that extension here. There's certainly no express authority for it. And as a matter of public policy, it would appear that it could disrupt the goals of finality. And remember, that's not only about protecting this court's finality, is not only about protecting this court's docket and its ability to have matters that are properly postured for decision, but it's also about protecting the superior court's ability to efficiently and effectively deal with the cases before it. If a matter is not final and is up on appeal, it has a dramatic effect on the superior court as well. So for all those reasons, and in addition, it also the governing statutes have taken a slightly different approach than with civil. In the criminal statutes, identify these are the specific bases for a defendant to appeal, and these are the specific bases for a criminal defendant. That is clearly a deliberate choice, and opening up a further mechanism for appeal that's a catch-all would seem to frustrate the purpose in specifying those specific items, grounds for appeal. I worry I may have that question.
I have no further questions. Yeah.
But,
I guess I do have a question.
yes, Judge.
You said one of the remedies is through interlocutory review. And is there authority to bring an interlocutory appeal from a dismissal order? Even if it's without prejudice?
I know of no case holding that an interlocutory appeal from a dismissal without prejudice of criminal charges is appropriate. I think that is an instance, though, where logically, if a decision is not final, if an appeal is not from a final decision, then of necessity, it must be interlocutory. And the interlocutory appeal process comes with the gatekeeping function of the courts determining whether the appeal is proper. That is not that's not as available in the finality analysis. So I know of no authority, but I think logically and of necessity, it would have to be an interlocutory appeal if it were not a final order or judgment.
Or potentially a writ.
Or potentially a writ. Again, as in the, defendant appellant identified the closest analogs, which is sort of the reverse situation, which is a dismissal denied, which are handled under this court's writ authority. And the statute, the plain language, the clear language of the statute would permit this matter to be brought for review to this court on these facts. With that,
All right.
thank you.
Thank you, Mr. Morris. Mr. Paul?
I want to make it clear that under Gutierrez,
Move the mic down just a
Sorry.
little bit. Yep.
I want to make it clear under Gutierrez that is where you question whether or not the court made their decision correctly. Gutierrez requires that the defendant make an objection. If there's no appellate right, then there's no purpose to making that objection. And again, if this court looks at paragraph 66, the government, quoting from the government, explained its reasoning to be for the purpose of continuing the investigation due to dissatisfaction with the current state of the case. And that was found to be grounds for dismissal with prejudice. That in no way is it appropriate for the government to dismiss a case for purposes of trying to get a better understanding of their own case, which is exactly what you could argue happened in this case. And I want to make it clear that in this case, the government argued that the defendant committed disorderly conduct, but never said any people were present, unlike the example that the government gives. And I do believe, though I don't have the citation here, that in one case, and it might be Mendola, that this court determined that one of the grounds for doing a writ is when this court has previously denied a direct appeal. So that if this court does deny a direct appeal, that would now be grounds for filing a writ on the issue. But again, what
about the government's contention and in reference to rebutting that there was any bad faith intent in dismissing the case because it wasn't prepared and it was for its convenience? It did make an effort to try and proceed with trial by asking the court that the witness be allowed to testify via Zoom. for the second option in reference to impaneling the jury, but suspending the trial until the witness comes back.
So again, so the first one is clearly a violation of the confrontation clause. And the government said they needed this witness because it's their main witness, that without the statement of the defendant that the police was going to provide, it could not move forward with the case. So it could not move forward. It should have been dismissed with prejudice because of that. Second, a 17-day delay is not insignificant when we look at 45 and 60-day periods for speedy trial as we have in Guam. That it is a violation of speedy trial. There was never any case law presented in their argument that would support that the police officer would be able to testify. And even though the government has said that there was no showing that, or the government said it was too expensive to bring back the police officer. That is not a good faith showing, especially since the government always has a greater budget than the defendant. And the fact that the government
Is that the case law in our jurisdiction that under certain circumstances, I don't know if it's exceptional, that a witness cannot testify via Zoom in a criminal case?
I don't know of anything that allow. Now they could have, under exceptional circumstances, the case could have been moved so that the witness could come back. But I do not know of any case law that allows in a criminal case, unlike a civil case, for there to be Zoom testimony without either the pandemic rules being in place or a stipulation. I see my time, I believe, is up. Thank you.
Thank you, Mr. Paul. Thank you, Mr. Morris. The court will take the matter under advisement and will now stand adjourned. Welcome to the appellate bar, Mr. Morris, and thank you, Mr. Paul,